Hello friends, welcome once again to the Supreme Court Historian YouTube channel. In today's video, we are going to discuss one of the lesser known important landmark judgments. It is not at all a famous decision, but it is an extremely important one as far as the rule of law in our country is concerned. This is a criminal law case, Harla versus the state of Rajasthan, verdict given by the Supreme Court of India on the 24th of September 1951. A seemingly trivial case. This gentleman Harla was arrested under the Jaipur Opium Act. Apparently, he committed an offence defined by Section 7 of the Jaipur Opium Act in October 1948. That's when he committed the offence. He was arrested, investigated, etc., tried and convicted, found guilty, and was punished with the fine, a princely sum of 50 rupees. So as I warned you to begin with, a seemingly trivial matter, 50 rupees fine, but he appealed against this and the High Court upheld the lower court's decision, confirmed his conviction, and asked him to pay that fine, to go ahead and pay those 50 rupees. That was his punishment. Harla nonetheless doggedly refused to give in and appealed to the Supreme Court, and the Supreme Court agreed to hear his case, and the Rajasthan High Court's decision was, believe it or not, overturned by the Supreme Court. Why is this seemingly extremely trivial matter so important that it goes all the way to the Supreme Court? A 50 rupee fine, how does it find its way? The origin of that lies in the origin of the definition of that particular offense. We don't even know exactly what offense he committed. It's not given in the judgment. Must have been something to do with possession of opium or perhaps distribution of opium, who knows. But the point is something else. The point is, what is the origin of that Jaipur Opium Act? And that is why such a seemingly trivial matter made its way all the way to the Supreme Court of India. And that is the story. Those are the facts that we really need to consider. It all began in December 1923, where the Council of Ministers of the princely state of Jaipur passed a resolution resolved to enact the Jaipur Opium Act. They did not actually promulgate this particular law. We don't know if it was promulgated. We don't know because it was simply not published in the Jaipur Gazette. So a little background of the Council of Ministers of this princely state of Jaipur. Jaipur itself lost its Maharaja in 1922, and his son was a minor when he ascended to the throne. So there was an agency, a regency really, and that regent appointed this Council of Ministers. So first of all, there is confusion about the sovereignty of that Council of Ministers. Secondly, the Council of Ministers, when faced with some opium issue in that princely state, decided that there will be a Jaipur Opium Act, but they did not actually come up with a text of that act. It was not promulgated. This act was not published in the Jaipur Gazette. Later on, a year later almost, on the 1st of November 1924, they passed something called the Jaipur Laws Act, which was published in the Gazette. Jaipur Laws Act 1923 came into force, and it included all regulations already in force into the list of laws to be administered in Jaipur. Basically, what the Jaipur Laws Act 1923 said was that the courts in Jaipur, in the princely state of Jaipur, will administer certain laws, obviously the laws which are in force, and this includes all the regulations which are in force today. And later on, 14 years later, in May 1938, the Jaipur Opium Act, the original act passed in 1923 or resolved in 1923, that act was amended, and one section of it was published. The new amended section was published in the Gazette, which brought that particular law in force from the 1st of September 1924. So as far as the police are concerned, they would claim that this Jaipur Opium Act is in force from the 1st of September 1924, and it had defined an offence in its section 7. This offence was committed in 1948 by our friend Harla, and therefore that conviction stands. Unfortunately for the police, the act was never published in the Gazette. So although the prosecution was able to prove that the offence was committed, they were not able to prove that the offence existed at all. Because when we look at the legislative procedure in any modern state, it includes these few steps. First of all, a legislation is introduced in the legislature in the form of a bill. The bill is then discussed upon by the legislature. If it is unicameral, then by that house. If it is bicameral, then by both houses. Once both houses pass that particular bill, then it becomes an act which goes for its signature to the head of the state, either the governor in the case of a state legislation or a state enactment, or the president in the case of an act of parliament. Once the head of state gives his or her approval, then the legislation is passed on for publication into the Gazette of the state or Gazette of the nation. Let's just take a look at what the Gazette of India looks like. This is egazette.nic.in. That is where the basically all the enactments in place are published as soon as they are enacted. Let's take a look at this example, recently published 12th August. Okay, let's unblock this particular pop-up, and here we go. This is how an act is published in the Gazette of India. This particular happens to be the National Anti-Doping Act, passed on the 12th of August 2022 and received the assent of the president on that date. So that is the life cycle of a legislation. It has to be it has to go through all of these steps before it can be considered to be a valid law. In this particular case, it was never published in the Gazette. So that became the issue before the two-judge bench of the Supreme Court, which heard this case. Justices Vivian Bose and Meherchand Mahajan. It was Vivian Bose who gave the opinion, who wrote the verdict. The issue before the bench was that the Jaipur Opium Act was never published in the Gazette, although its amended section in 1938 was published. Is an unpublished law valid? Is it in force? Or does the maxim that we apply, that we learned in our very first semester in law school in criminal law, ignorantia juris non excusat, does that maxim still apply? Ignorantia juris non excusat, you cannot claim to be ignorant of the law and then break the law and say, oh, I was not aware. Is murder illegal in your country? I was not aware. Shall not happen again. You are not allowed to make that defense. Let's not take murder. Let's take the most common offense tried by the courts in our country. Section 138 of the Negotiable Instruments Act, that is the bouncing of a check, a dishonored check. If you were allowed to claim the defense that you were not aware that allowing a check to bounce is a criminal offense, you would not have done it. Now, going forward, I will not do it. Now, let me go. No, that particular defense is not available to you. Ignorantia juris non excusat. It is not a good enough excuse that you were not aware of a law. But what do we mean by being aware of a law? How do we, the people, how are we expected? When is it that we are thought of to be aware of a particular law? When is it that we can no longer claim that we were not aware? The answer is very simple, very straightforward. When that law has been published in the Gazette. If it has not been published, can we be said to be aware of it? It is not the case, as per Justice Vivian Bose, and he relied on the principles of natural justice in arriving at this decision. Natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcast in some recognizable way so that all people may know what it is. It would be against the principles of natural justice to permit the subjects of a state to be punished or penalized by laws of which they had no knowledge and of which they could not even, with the exercise of reasonable diligence, have acquired any knowledge. Obviously, even today, despite all of us being educated and literate, we are not genuinely expected to know all the laws in place. Even all our lawyers, even all our judges are not really expected to know every law that is in force in our country. But as long as it has been published in the Gazette, as long as it is accessible to us when the need arises, when we enter a particular sphere and we are trying to make our firm or business or trade to fall within the realms of law, then obviously we do our research, um, or we consult an expert in the subject, a lawyer usually, and then we have carried out the reasonable diligence that Justice Vivian Bose is talking about here. This is required in natural justice. Natural justice, there are three principles that we have discussed before. One being that you will hear the other party, you will hear both parties before passing a judgment. Second being, you will not pass a judgment in your own case. And the third is notice. Appropriate and reasonable notice should be given before you can adjudicate against a person, and this will then fall under notice. If we are simply not aware that a law exists, how are we expected to follow it? When can we claim that we were not aware that this law exists? When that law was not published in the Gazette. The other complication, slight complication, existed in this case, which was the later act, the 1924 enactment, the Jaipur Laws Act, section 3B of which said that the law to be administered by the court of Jaipur state shall include all the regulations now in force within the said territories. All the regulations now in force within the said territories. The claim being made by the prosecution was that this particular resolution falls under the list of all regulations now in force. And the court, the Supreme Court, led by Justice Vivian Bose in this particular situation, threw out that argument as well. The very words are all the regulations now in force. If it is not published in the Gazette, then it cannot be said to be in force. And in fact, the situation is explained later on in the same section. All the regulations now in force within the said territories and the enactments and regulations that may hereafter be passed from time to time by the state and published in the official Gazette. So it can't be that only future regulations and enactments are to be published in the official Gazette. Everything has to be published in the official Gazette, as we looked at that anti-doping enactment as an example. So the verdict was quite straightforward. The appeal succeeded, the conviction and the sentence were set aside, and the 50 rupees fine, if paid, was refunded. A very straightforward case and very easy one to decide, but its ramifications are quite evident. This particular case, this very tiny criminal law trivial case, which really should not have perhaps been even prosecuted for a 50 rupee fine, which was not a big sum even back then in 1950 or 1948 or whatever. Nonetheless, it made its way all the way to the Supreme Court, and it has been referred to by dozens of Supreme Court judgments that came after this, and by many more, almost 100 more High Court judgments across the various High Courts of the country. It was that important a principle. You cannot be prosecuted or penalized under a law which has not been published in the Gazette. So a nice little instruction for all future governments. Enacting the law is not enough. Getting it signed by the governor or the president is not enough. It only comes into force on the appointed date as long as it has been published in the official Gazette. Harla versus State of Rajasthan. Hope it has been instructive. See you again next time. Bye-bye.